Right, back on the Newsfeed PM. Thanks for staying on. Eligible Koisan communities and leaders were urged to submit their final applications for recognition under the Traditional and Koisan Leadership Act 2019. This final call issued by the Commission on Khoi-San Matters in line with Section 56, subsection 2 of the Act marks a historic moment in affirming the identity, rights and role of the Koisan community within South Africa's traditional leadership system. Let's talk more on this milestone. We're joined now by Deputy Minister Burns Ncamashe and Verrie II of the Greater Aboriginal Community Council of Southern Africa. Larry, let's begin with you. Good to have you, and thank you very much for joining us. How do you feel about this final call and, of course, all the hurdles that you've had to go through, particularly to get to this point?
Good afternoon, Thabo. Thank you for having me. Look, I think what is important to mention with the Act and the Concord giving a ruling, I think 2 days ago, for that was the state kicking the can further down the road, because we've been waiting for more than 30 years for the state to recognize us. But I think in terms of what is important for us, we do not submit to the Koisan Commission. It is, in our view, unconstitutional. We were not part of that process. And what is important is that TKLA, the Act, does not empower Koisan communities. It actually politicizes our identity. It domesticates our authority, and it changes our leadership to the interest of the state, because now it becomes about politics. So under this Act, a Koisan leader can't exist without the minister's approval. We must apply to the state, to a state-appointed commission, to be recognized, as if our existence is debatable. So this is contrast to that of the Zulu king, because, for example, where the government recognizes him or not, he is still the king. His recognition is political, but his power is cultural and historical. Yeah. And the importance is, it is not granted by a commission. It is not taken away by a minister. His legitimacy does not hang on the signature of a director general. But for the Koisan community, for the first people of this land, they are legally invisible unless the state says otherwise. We cannot act, we cannot lead, we cannot even organize without permission. Now that is not recognition, that is administrative captivity.
Yeah.
The other thing is that
let's bring the Deputy Minister in here. I'll bring you back again, Larry. But yeah. Deputy Minister, I mean, already as we begin the conversation, it feels as though the community feel this process has been politicized, made around the requirements of the political elite, ignoring what the community itself would like done, and they consider that process particularly unfair, but also the very requirements themselves are sparking a debate of unfairness and the legitimacy of the process being brought to question. What does government have to say on that?
Well, let me first greet you and your viewership, extend my greetings to Larry as well. And I think the first thing to do would be to dispel what seems predominantly to be perceptions than facts. I think Larry, if he will go down the memory lane, he will realize that the Traditional Leadership and Governance Act of 2003 made provision for the first thing that government must do: investigate all the paramount chiefs who were recognized before the legislation at the time. And that was done through the Nhlapo Commission. And that did not leave any stone unturned. It included all paramount chiefs. By the way, including the Zulu king. He was one of the paramount chiefs at the time who were investigated. And out of that investigation, he was then confirmed to be the king of a kingship, which was confirmed again by that commission. So to suggest that the Zulu king is given preferential treatment or treatment different from other kings in South Africa in terms of the investigative processes is devoid of truth. It doesn't carry the weight of facts. Right. It's not confirmed in terms of the law. Yeah. So those are the things that
what about the constitutionality of the Koisan Commission? What do you say to respond to that?
I like that question. South Africa is a constitutional democracy. The Constitution of South Africa is the supreme law of the land, which applies to everyone, including the Khoi-San. So the Traditional and Koisan Leadership Act is as a result of Chapter 12 of the Constitution, both Section 211 and 212. What it says is that all institutions of traditional and Koisan leadership will be recognized following a process that is constitutionally compliant and statutory consistent. So the Koisan will not be treated differently than all other ethnic groups that we have in South Africa.
So the view,
all that we want.
The view that you are imposing bureaucratic hurdles that would mean their very existence as the Koisan community really hinges on whether the minister feels he wants to recognize them or not. You're saying that's far from truth?
It's devoid of truth. What we expect, if Larry has got a claim, he must submit it. And that claim will be subjected to an investigative body, just like all other ethnic groups. So to avoid subjecting any community or leader to a process of scrutiny and clutch on straws, it's not going to assist. We want to urge everyone who believes that he or she has a legitimate claim to leadership position. Come up with your claim. We will test it. It will be subject of scrutiny. And you will be recognized. There's no question about it. We know the history of the Khoi-San. That's why we consciously took the decision. We're not going to be taught about it. We know it.
Larry, it looks like very simple things here. One is that all paramount chiefs have been investigated. It's not any different what would have been happening with the Koisan community. Secondly, the commission is quite constitutional, recognized in Chapter 12. What is law in the country is also law for the Koisan community. And number three, if you have a claim, submit it.
No, you see, if I can come in there, Tabo. The minister or the deputy minister is making a reference to the Traditional Leadership and Governance Framework Act of 2003. But what he doesn't mention there is that in that act, traditional leadership would only be recognized if it could be linked to structures that were already recognized in 1927 under the colonial and apartheid legislation. Now, if we look at what has happened under apartheid, only the Bantu people, the Bantu community was recognized, and their cultures, their homelands. We never had any of those systems, so which means we weren't looked after under the apartheid government. So making a reference and saying that the Koisan community has always been recognized is a false statement. Now, this is if that is true, that the state had all the intention, the best interest of the Koisan community, then it wouldn't have taken 30 years in the first place. Whereas the Bantu community has received that as early as 1996 under Chapter 12 in the Constitution. So it is a completely false statement that the deputy minister is making to say that the Koisan community is undergoing the same process as which the other communities are going, because none of them had to apply. That is the bottom line. How is it that the Koisan community in the first instance, and this is the most important thing that we need to deal with, is that we have to apply for recognition. No other community has been asked to apply for recognition. That is the foundational truth that we must recognize when we're dealing with this act. And that is why I brought in the statement about this is a political game that they've been playing all along. They've been playing this game, and this is why how can a minister who is, if the Constitutional Court has recognized the Koisan community and their laws and their systems and their chieftaincies to predate the formation of the South African state, how is it then that a minister can then decide whether this person can be a paramount chief or a leader, and then later he also has the permission to take it away, has the power to take it away? That can't be. And then how is it that he's saying that on that very basis that we are equals, or we are being treated equal to the so-called black traditional leaders?
Unfortunately, I'm out of time. I'm going to have to leave it there. But a quick 30 seconds, Deputy Minister. I don't know if you can. This is where the process is now. The leadership says this process is not legitimate. Government is defending its process. How is this going to be resolved?
You see, what Larry is saying, we are used to it. If you have a claim and you believe it is legitimate, bring it. It will be tested. We are not going to compromise on that.
We'll see you guys in court. I can tell you that much.
You're welcome. You're not going to threaten us.
Yeah. We are not threatening you. That is the Constitution. So we must see what the Constitution will say about what is law and what is not.
So we were with you.
It does seem that, Deputy Minister, the only solution to this is to take it to court. The legal system is the one that's going to determine what will be the outcome.
Ready for Larry. Bring it to court. We're ready for you.
All right.
We'll take it to court and we'll see what happens there.
Let's leave it there. All right, let's leave it there. Deputy Minister Burns Ncamashe, Verrie II of the Greater Aboriginal Community Council of Southern Africa. It does look like it is heading for litigation at this particular point. Legal challenge looms in this matter of the recognition of the Khoi-San community. The Newzroom PM continues shortly.